comes the Melly that there's an institutional bias, prejudice, and advance this case be dismissed.
The YNW Melly murder trial had an intense motion hearing today. They discussed motions that involve throwing out the state attorney's office from the case. Melly's lawyer says that the state attorney's office want to win at all costs, even if it means lying because the case is high profile. They're quoted saying the state attorney's office has an institutional bias and prejudice towards Melly that demands for this case to be dismissed. The judge also responds to the motion to suppress situation where the state asked him to reconsider everything in my last video, and you're going to see what happens with that. A lot's going on in this video. The audio is terrible. I took a shower halfway through. Sorry. Hit subscribe. Here we go. All right, so we got defendant's response to state's motion for rehearing, reconsideration, and clarification right here. Defendant files this response in opposition to and request to deny the state's motion for rehearing, reconsideration, blah, blah, blah. However, nothing here should be considered as the defendant waiving any future appellate rights or even agreeing with all the court's rulings. The defendant filed 13 motions to suppress and believes that each one should have been granted in totality and that all evidence seized under search warrant should have been suppressed. Okay. The state says before the trial court considers the merits of a Fourth Amendment motion to suppress, the defendant must first establish a factual basis justifying his or her claim to have possessed Fourth Amendment right at the time of the alleged invasion. A more recent case would have required the state to have raised and preserved the issue of standing at the time of the motion to suppress, not 9 days after this court ruled. The defendant notes that the state relies on no Florida cases or even 11th Circuit cases to limitation of scope from service. Rather, the state apparently wishes that it was in Colorado or Kansas, as it heavily relies upon 10th Circuit federal law. Mellys Team is trolling these boys right here. The state never raised the issue of independent source prior to their motion for rehearing. It is not mentioned in their omnibus response to the motion to suppress, nor was it raised at the time of the hearings. It was abandoned by the state as they produced no testimony or evidence that any information that they received from any of the search warrants they executed had been gained through an independent source. The state argues inevitably discovery and independent source as if they are one concept. They are closely related but are different concepts of law. All right, for the motion to suppress on the iCloud, let's see what Mellys Team has to say about what the state said. So remember, this is a response from Mellys Team to the state saying that the court got it all wrong. A lot's going on here. The state again raises the standing issue. They wrote, because the defendant was not forthcoming or whether or not he was still proceeding with the strategy of claiming the film was not his, the state proceeded with the argument as if he had standing at the time. However, standing was addressed in the initial response filed by the state and briefly addressed during the argument on November 21st. The state later indicates it raised the issue of standing. If the defense was not forthcoming whether or not he was still proceeding with the strategy with claiming the film was not his, then why would the state proceed with the argument as if he did have standing? This is such a clusterfuck, dude. The state is acknowledging they have waived the issue of standing, proceeding on as if the defendant did have standing. I mean, this is like almost riddles, bro. Now they're quoting the state right here saying, standing was addressed in the initial response filed by the state and briefly addressed during the argument. It is not a correct recitation of the record. Standing was not addressed as to the phone in this motion and the state's omnibus response. The state never contested standing in this matter, as it was way more than obvious that the defendant did and does have standing. The defendant introduced the affidavit for search warrant, which was sworn to and admitted into evidence without any objection. In the affidavit, Melly states the following. This detective is requesting a warrant pertaining to the data stored with the Apple iCloud phone number. The phone belongs to Jamal Demons in this case. This affidavit alone acknowledges that it is his phone, his iCloud account, and that it is known to others to be his phone and iCloud account. If standing was an issue, Mr. Demons has standing. All right, so here's a dumbed down sentence for you guys. The state's position seems to be simply, from service providers, we get so much information that it becomes so time consuming and tedious. Fourth Amendment protection should go by the wayside. Law enforcement's time is more important than the citizens' rights, and who wants to burden the service provider? Pretty good point from Melly's lawyers right there. The state suffers from knowing too much. That is, they have 4 years of investigation behind them. They interject their opinions and facts that were not known at the time of the writing of the search warrant affidavits and signing of the search warrant. The state goes through a litany of justifications in need of the items that this court suppressed, possibly if the contentions were made in the affidavit for search warrant and referenced therein. There must have been probable cause and a nexus. However, the state's after the fact 4 years later, recitation of why they need the evidence is improper and not legal justification. The state has put together arguments that, had they been contained in the affidavits, may have led to probable cause, nexus, and even an expansion of this court's ruling. However, they are not contained in the affidavit and they are not a part of the court's review. They were not testified by Moretti at the hearings, therefore they are not based in evidentiary fact. The state said it is common knowledge that defendants claim a device is not theirs or that it is a community phone used by many. The identity of the account device user at the time of the homicide must be proven. In order to prove that identity behind the keyboard, the state must authenticate that device as the defendant's. In order to do so, the pattern of life must be shown, which requires going beyond the mere 6 hours permitted by the court's order. Now we're talking about the time frame of the 6 hours from 3 a.m. to 9 9 a.m. And now this is what Mellys Team says about that. Whether this is common knowledge or not is up to debate. This justification to expand the 6-hour time frame that the court limited was inappropriate as it is not contained in the affidavit. It goes on to argue in other orders by the court, and the time frame is 30 to 45 days. They then argue that the same time period should at least pertain to this motion and court order. They fail to realize that each motion was independent to itself. They fail to realize that each affidavit is independent to itself. They fail to realize that the probable cause in each affidavit is independent of itself. They fail to realize that a 30 to 45 day time period may or may not be appropriate in some situations dealing with search warrants. However, what this court did as far as the time frames and other warrants had no bearing, is independent of, and has no relevance to what the court ordered in this motion to suppress. So the state comparing each motion's time frame to each other is wrong because apparently they're all independent. Withers in a recorded statement says he was communicating with Melly on Snapchat. Okay. If standing was an issue, which is not, the affidavit alone confers standing upon Mr. Damon's. In the state standing section for Snapchat account, there's a more perplexing and irrelevant statement. So right here, they're pointing out that Mellys Team constantly objected to Miss Bradley in the first trial, saying that Melly's phone was Melly's phone on the screen or in front of the jury. Somehow the state wants a negative inference that requiring the state to do what they are required to do at trial has a bearing on standing. In this section, the state once again contends that only the four corners of the affidavit should have been looked at by this court. They also fail to explain how they could argue inevitable discovery and independent source without testimony. Rather, the state seems to be under the belief that no testimony should have been allowed, but their representations within their motion for rehearing should alleviate the need for testimony and evidence. The state's position seems to be that they can't put on witnesses to establish inevitable discovery or independent source because that would be outside the four corners of the affidavit. However, they apparently believe that this testimony should be supplemented by the state after the hearing is over and after the court is ruled with factual allegations and arguments that are not part of the record. Now, talking about the nexus, proving the user of the account and relationship context. The problem with the state's motion for rehearing is that it is a mixture of legal argument, facts from the affidavit, facts from the hearings, and quite candidly, facts that they decided to interject. For example, on page 24, the state states, furthermore, the court's ruling overlooks the fact that this investigation at this point had revealed that a lot of Demon's communications were through a social media. In the affidavit for Snapchat account, as to communications by Demons through social media, the following is contained. The author revealed that other communications were in use as the CDR for Demons made reference to data for the cellular device of Demons based upon CDR of other communications were in use but not known to this investigator. There's nothing in the affidavit that revealed that a lot of Demons communications were through social media. Also, there's nothing in the affidavit that would indicate what stage the investigation was in as to what social media accounts. So Mellys Team is saying they didn't add any of that in the affidavit. This has been an issue before in this trial where Mellys Team is always saying that Moretti didn't add a lot of common sense to the affidavit. So now I guess they're pulling that card again. The state likes to state that it is well known, the defendant will say, it is well known Donald Trump has a Twitter account that is now an X account. It is also common knowledge that he alone does not do all the posting, as it is common with many politicians. Allowing somebody to use the account or help you with it does not divest Donald Trump or Jamel Demons of standing. Damn, so they're saying because since Melly had someone else using his account, doesn't, you know, give them the right to take his rights away. All right, so a lot of accusations from both sides. Now we're gonna get the judge's decision on everything. So this is the part of the video that will be easier to understand because I'm even struggling to understand this shit. Order on the state's motion for rehearing and reconsideration. Having considered the state's motion, defendant's response, and the state's reply, the court file, applicable law, and otherwise being fully advised, this court finds as follows. The state has not established that the court overlooked or misapprehended any points of law or fact. So the judge is not in favor of the state. They're in favor of Melly. All right, here we go. The state's argument about defendant's lack of standing, which would only apply to defendant's cellular phone, is not well taken. Defendant has established a possessory interest in the cellular phone at issue in his motions to suppress, and there was no evidence presented that the defendant disclaimed his possessory interest in the cellular phone or otherwise abandoned it. Trial counsel's strategy at the first trial is not evidence. As clearly stated in the court's omnibus order granting, denying, or granting in part and denying in part defendant's 13 motions to suppress, the court's ruling in no way precludes reconsideration of the order if it becomes apparent at any point in the proceedings, including during trial, that the defendant is disclaiming a possessory interest in the cellular phone. Big ass word. So basically, Mellys Team did have an interest in one of their motions to suppress in the cell phone. So everything the state claimed was wrong. The state also takes issue with the court's decision to allow defendant to elicit testimony from Detective Mark Moretti as at the hearings on defendant's motions to suppress. However, as stated in the court's omnibus order, the court did not consider Moretti's testimony when determining whether probable cause existed within the four four corners of the search warrant affidavits at issue. Rather, the court only considered Moretti's testimony as it relates to the issue of whether he relied on the search warrants in good faith. The state once again conflates the service provider's inability to search through the contents of the records requested to determine which records are relevant to the homicides with the service provider's ability to narrow the category of data based on the criteria such as file type and date ranges that are unrelated to the actual contents of the records or data. The court did not find that service providers have the ability to determine what data is evidence of a crime. Rather, nothing presented in either the search warrant or in Moretti's testimony indicates that service providers cannot limit production of data based on categories and timeframes which are unrelated to the substantive content of those records. Once again, the state conflates the necessity of seizing wide categories of records and data based on service providers' inability to determine what records or data contain evidence of a crime with the authority of law enforcement to search the entirety of the records and data provided. While law enforcement may have to search through the records to determine whether they contain the evidence of a crime, there was nothing to indicate law enforcement was unable to restrict their search and based on non-substantive record categories and or in timeframes. So they're saying there's nothing in Moretti's testimonies or search warrants that say that these companies can't shrink down the range of data that they provide. So they're still blaming Moretti for getting these wide ranges of information, pretty much. The court is. The judge is blaming Moretti for that. The state also argues that the time limitations imposed in the omnibus order are arbitrary because the timeframes imposed for different warrants are not the same. As clearly required by law, the court could only look to the four corners of each individual search warrant affidavit to determine the appropriate time limitations based on the facts in each individual search warrant. So the judge is saying the same thing Mellys Team said, that each search warrant is different. They have to look at the four corners of each search warrant to determine how long the time frame should be, either 3 to 6 a.m. or fucking a month or two. Y'all remember? The court cannot incorporate the facts present in the Facebook or Instagram affidavits and other affidavits for the convenience of uniform time frames. Likewise, the court will not consider any of the extrinsic facts set forth by the state in its motion for rehearing. It does not allow the state to move for rehearing based on inevitable discovery or independent source doctrines, issues with the state failed to raise prior to the court's ruling, even though the state filed a detailed omnibus response and had ample time to present argument at hearings. However, does not preclude the court from exercising its inherent authority to reconsider a motion to suppress while the court still has jurisdiction over the case. The court will not exercise its discretion to reconsider the issues that were already considered and ruled on its omnibus order. The court finds that the state's arguments as to those issues have no merit and there's no good cause for the court to reconsider those issues. Damn, bruh. So the judge is standing strong. He doesn't want to change anything. He's not reconsidering shit. Basically. Here's our first look at Melly in like a while. He's, of course, praying or something. I don't know. Bro is asleep. I haven't seen his eyes open. Oh, there he is.
They underlined inaccurately relate to the state attorney administrators that she spoke with Detective Moretti regarding this incident, and that Detective Moretti explained that his statement to Deputy Brawl was a joke.
Oh my, I still can't believe we're discussing the Moretti and Melly's mom situation, dude. I'm so over that shit.
There was never an objection. The defense in this particular matter, when Mr. Klinger cross-examined, now all of a sudden, there's a problem.
District attorneys right there just said they never objected to something. I can't hear this, by the way. I'm like kind of hearing 2 words each sentence.
Understanding that there was an objection then. Why all of a sudden now is there a reason to now call Mr. Klinger regarding this particular matter? When Mr. Klinger said, he was on the record.
All right, the motion to grant, I'm going to squash this because I'm not allowing this to before the testimony of the state attorney for the same reasons that I gave before. I understand certain things may have changed.
So I believe I heard the judge quash some subpoenas right there, and I think it was for State Attorney Pryor, Chief Assistant Falk, and ASA Killeran must be quashed because the violation of the October 12th order of this honorable court, quashing the subpoenas and granting a protective order. So those 3 people from the State Attorney's office won't be testifying. That's what the defense was trying to do.
And Ms. Boutros realizes when she's watching the trial from home.
So now he's talking about Ms. Boutros realizing that the state never gave over the Brady notices to the defense about the whole situation.
The Brady material wasn't given to us. Eventually, the state attorney's office, Ms. Bradley, sends out a Brady notice. Mr. Killeran then files an amended Brady notice saying that what Ms. Bradley said was incorrect. Then Ms. Bradley turns around and corrects Mr. Killeran and saying that he didn't know what he was talking about. What happens to Ms. Bradley? Nothing. She came back before this court. The prosecutor on this case disobeyed their order, their directive, to issue a Brady material. The prosecutor on the case allowed the case to go to trial. The case ended up with a hung jury. And then afterwards, the state attorney's office finds out that this prosecutor did not send out Brady material. This state attorney's office cares about one thing. That is true.
Why did they not send that Brady notice? Because the state attorney's office cares about one thing, and that's winning.
The state may never have used the word liar, but they've used the words that she told untruths. They've used every synonym for liar.
I've said this a lot, but I believe Boutros lied a little bit. Let's be honest. She's on audio apparently saying one thing, but then testifies another thing.
And then Ms. Boutros, being the white knight, so to speak, she did wrong. She is the one that gets punished by this office. They disparage her character. They bring up bar complaints. They bring up anything they can about Ms. Boutros to make her look bad. The state has already made its intentions known that they intend to cross-examine her. So we now put on Ms. Boutros as a witness.
Bro stays yawning, dude, every time.
Even the people that she works for don't believe her, and that nullifies her credibility. Not because of her truth, but because of her status as being a state attorney in this state attorney.
This judge looks so over there.
I found no case in the state of Florida where the witness is adverse to the state attorney's office. Every case deals with that assistant state attorney who is testifying being on the state attorney's side. Here we have the opposite instance.
In the deposition, that's when he's asked if in fact he had worked with Ms. Boutros afterwards. He says yes. Ms. Boutros testified she did work with him again. Another instance. That's what prompted the state to look into this.
I like how the prosecutor's actually talking pretty loud so we can hear Melly's lawyers be mumbling, bro.
No matter who you are, if you take the stand, you put your credibility at stake. And so now we have concerns that things are not lining up.
Pointing out that Boutros is a liar, turning on their own. That's crazy. This state attorney's office is fractured.
We've never called Ms. Boutros a liar. The purpose of impeachment is inconsistency. And the jury would theoretically hear a statement was made inside court, a statement was made outside of court. Those statements don't match.
They're not calling her a liar. There's just inconsistencies on statements.
What the jury instruction basically reads is, if there's an inconsistency, you should not consider the witness's testimony as reliable. So what we have now is a witness whose testimony is not consistent. And all we have laid out is that, again, the evidence does not support this claim that they're making.
See what the judge says?
Title State's response to defendant's motion to recuse State Attorney's Office of the 17th Judicial Circuit in Fort Broward County, Florida. And at page 2, Mr. Klinger writes, moreover, the state has not created a dispute in the evidence. Just as it did in the prior trial, the state will not be calling any assistant state attorneys or the elected state attorney for that matter. If, in fact, the defense decides to have ASA Boutros testify as a defense witness, she will not be cross-examined by the state. There is no inherent right to disqualification when a member of the state attorney's office is called as a witness in a case prosecuted by the state attorney in the same office. That's Mr. Klinger when he represented the court. Then at the hearing, they also say there's a conflict, but there is no conflict. We don't dispute anything that Ms. Boutros said on the stand. Didn't cross-examine her on anything other than just to clarify a couple of issues. But it wasn't the facts. We agree with them. We probably could have just stipulated most of her depositions. So there's no conflict.
The state at one point said they weren't going to cross-examine Ms. Boutros, but then they did briefly, and that caused conflict. And that's the conflict they're talking about, that they did actually cross-examine her.
That's what you told me, what Mr. Klinger did. And now it's a different story.
Because cases are fluid, as I told the court. When we spoke to Detective Moretti and he gave the deposition, more information came to light. And of course, as prosecutors, you're going to be bound to investigate and discover what the truth is. And so what we've done...
Representations are fluid too. We're not going to cross-examine her as a witness if she's called by the defense. We're not going to cross-examine her. That's fluid too. Your representation of that, that's fluid. That doesn't mean anything. I can go ahead.
Me cross-examining her or another office, she's going to be subject to cross-examination. Recusing an office is literally like the last measure that the court has to do. And in this instance, it doesn't demonstrate how the defendant is prejudiced.
If I'm hearing the state attorney correctly, what they're saying is nobody can rely upon the representations of the state attorney because they are only as good as the second that they are said. And 1 second after they are said, they have no meaning.
That was a mic drop statement right there.
Where expedience say, have Mr. Klinger come in and say, we're not going to cross-examine Ms. Boutros because that was maybe the linchpin.
So 2 different state attorneys said different things.
And then turn around and do the opposite. I mean, we all have some allegiances to the Constitution, to whatever. But if you represent something to the judge, it better be true. You represent actions you're going to do in the future. It better be true. But this state attorney represented that Ms. Boutros was not going to be cross-examined and that they agreed with her facts of the case. And now this state attorney turns around and says, we don't agree and we're going to cross-examine. And I'd like to know why Mr. Griffiths cross-examined Ms. Boutros the way that she did, that no matter what it takes. Mr. Klinger, you say what you need to say if we want to win this motion. Mr. Griffiths, you say what you need to say because we want to win this motion. Even if they're opposite, it doesn't matter. Winning at all costs is everything in this case. High profile.
Winning is everything because it's high profile to the state attorney's office.
This case would scream for recusal, but it's not being recused because it's high profile. And this is the splash that the state attorney wants to make. You send out, she'd be more sure to send out a Brady notice. She doesn't like it. Mr. Kilrin sends out a Brady notice. She doesn't like it, and she overrules Mr. Kilrin with a new Brady notice. Nothing happens to Ms. Bradley whatsoever. Ms. Boutros, on the other hand, as you've seen, is attacked in all different fashions by the state attorney's office. It's institutional. It goes from Mrs. Bradley up to the state attorney and back down to the prosecutors in this court. When it comes to Jamel Bevins, for whatever reason, there's an institutional bias, prejudice that demands that this case be dismissed.
They're saying this shit's institutional, needs to be dismissed.
This demands disqualification. what's gone on in this case with this state attorney's office demands disqualification.
The judge is not going to dismiss this case. I can tell you that right now. That's pretty much it. The judge didn't really rule anything because there's some scheduling issues besides quashing the subpoenas for the other people in the state attorney's office. But Mellys Team is fired up. They're still trying to dismiss this case. Really doubt it's going to happen though. But the judge stood tall on his motions to suppress and didn't change his order at all. So yeah, comment down below what you guys think. Hit subscribe. Love you guys. Peace out.